The recognition and implementation of rights framework was announced on February 14th, 2018 by the Prime Minister in the House of Commons. It's going to be a series of policies and law passed by the Parliament, and they want to introduce it before Christmas break in December of 2018, and they want it passed before the next federal election. So that means it really has to be passed by June of 2019, because they'll be calling an election shortly after that. It's important for the Aboriginal title rights and treaties of Indigenous peoples. Those will all be impacted by this legislation if it passes. It sets up the law that they propose sets up a process where you have to apply for federal recognition to be recognized as an Indigenous nation or collective. We don't know what a collective means. It seems to mean a number of Indian Act bands. It could be non-status groups. We're not sure. That's not clear. But they're talking about you have to go through a process of federal recognition as an Indigenous nation or a collective. So that's one of the issues. It's really a conversion from the original relationship with our lands and treaties and into a new relationship under these agreements that, this recognition process and agreements that they want these new Indigenous nations or collectives to sign with the federal government. And part of that is that they also want to set up institutions, advisory institutions, to help determine the criteria and give advice on whether a group, a band or whoever it's going to be, can be recognized as an Indigenous nation or collective and added to the schedule of the law. In other words, be put on a list under the law that you're a federally recognized Indigenous nation or collective. They also want to list powers. They're also going to have a set of definitions of key terms, which may or may not be in the law, but they want to use those definitions to guide the legislation. So that's problematic because they're putting policy definitions to terms like treaties, Aboriginal title, the inherent right to self-government. The federal government is limiting the meaning of those through their definitions. So that's a problem. And they also say that Indigenous nations or collectives under this new law can set up governments whose authority will be the same as a natural person. So that means like a corporation. Could mean like a municipal corporation. But it means that they want to take Indigenous nations and put them into a lesser status actually than even municipalities in Canada, and under the control of provinces and of course the federal government. The Prime Minister has called it the fourth level of government. So this is what they're talking about, is a new order of government they want to create under this federal law, and it will be a fourth level order of government after municipalities. And so these are the things that they want to do, and it's going to affect treaties before 1975, the original treaties, and it's going to affect the modern treaties. And so this law is sweeping. It's the largest, it's just as big as when they passed the first Indian Act in 1876 without our involvement or consent. This Recognition and Implementation of Rights Framework Act is just as big and will have impacts on us this generation and for generations to come. Another thing that Indigenous peoples need to know about this proposed federal law, Recognition Act, is that it's only for on-reserve lands, really, for when it involves First Nations. Basically, anything that involves the provinces, they say in the structure of the legislation that the provinces have to have an agreement on anything that touches on their jurisdiction. So in effect, the provinces get a veto. On the one hand, they're telling us that free, prior, informed consent doesn't contain a veto, but the provinces get a veto in anything that touches their jurisdiction, including provincial lands. So if we talk about our off-reserve lands, territories, and resources, they're under this federal law. It says we have to have an agreement with the province that we're in order to have that included in an agreement. So the federal government has done a national engagement process, they call it, but it's been selective, and it's been really a top-down process. They've been talking to provinces, certain chiefs and certain organizations and certain Canadian citizens groups, but they have not gone and talked to all the 630 First Nations communities across Canada, who are the rights holders. They've completely bypassed them in the 3 years they've taken to develop this proposed legislation. And in the legislation, there was a national, Assembly First Nations held a national forum on First Nations rights in early September. And at that forum, there were quite a number of First Nations leaders who were calling for a halt to the process, including chiefs from the Ontario region. They actually had a resolution that was passed by the Assembly First Nations, which calls for the federal government to put a halt to this process. Other regions like British Columbia have proposed drafting instructions to basically have a federal law that would be based on principles that are based on recognition of inherent title and rights. But the drafting instructions coming from the BC Chiefs region is totally different than what the federal government's proposing in a document that they released called an overview document in September of 2018. So there's a big gulf between the two versions. And in fact, in August, I believe it was August 22nd, 2018, Indigenous lawyers wrote to the Prime Minister calling for a reset of the process because they're saying that what they're seeing from the federal government, their version of a proposed law, doesn't even recognize existing case law that's developed where they've recognized Aboriginal title and rights already under existing court cases. And so they're saying that the proposed law that the federal government's coming up with isn't even respecting the existing legal court cases. So we have a coalition of Indigenous activist networks made up of Defenders of the Land, I Don't Know More, and the Truth Campaign. And we've been trying to create awareness amongst our people about this law because it's been developed in secret through selective engagements. Many of our people don't know about it. In fact, many community chiefs don't know about what's in this law. So our first step has been to create education materials, to do teach-ins. We're going to be doing a webinar to try and create the awareness. And after we create the awareness about the threats of this proposed law to our rights, to our people, to our lands, we want to see our people get mobilized and let Ottawa know that we object to this law. We want them to start over and start talking to our communities about what the relationship should be and how we want to see the UN Declaration on the Rights of Indigenous Peoples and other international covenants on human rights applied to our nations, instead of having the federal government define all of that without our involvement or consent.